Give me a moment here. I'm going to restart this timer here and let me get this technical difficulty sorted out, and then we're going to start right up. One more time on the song, get the timer reset. Be right back. Okay, now we're good to go. Oops, come on. There we go. Greetings, one and all, and welcome to Society of Slaves, Part 2. We're going to take off from where we let off last time. But before we do that, just to remind everyone, this is just strictly for the entertainment, educational purposes of this YouTube channel, not to be used, misconstrued, or mispurposed for anything legal, lawful, personal, private, financial, tax, or otherwise. So please don't do this at home. Excuse me. All right, and welcome to Audit Them, Facetious Expert, and everyone else that's in the house. That's all I have on the chat here. You'll have to type in something new, and that will show up. There we go. That one guy. Finally caught alive. Well, you'll be satisfied with this one. This is a great piece here. So let's start with it. And greetings to you, Bill Thomas. So we're reading from the Treatise of Society of Slaves and Freedmen. This is a publication by Byron Beers, or by Ron Beers. I guess he prefers to be paid in beers. That said, here we go. From the introduction, we're just going to go over this, and we're going to right back to where we left off. This writing is not meant to be read by contented slaves, but rather to aid those who know they are not slaves, and for those who have an earnest desire to remove the ignorance that binds men. According to the Bible, the people are not to be slaves or servants of men. We have a few little readings here. And it shall be forgiven all the congregation of the children of Israel, that the stranger that sojourneth among them, seeing all the people were in ignorance. For thy merchants were the great men of the earth, for by thy sorceries were all nations deceived. And this one here will take us into the reading we're doing today. For thus saith the Lord, ye have sold yourselves for nothing, and ye shall be redeemed without money. From Isaiah. So from that, we're going to get right to where we left off last time, was to the words of individual. Wait a second here. So from this Supreme Court ruling here, I think this is, the penitentiary inmate was considered the slave of the state. It's Commonwealth 1871. And this was cited in this case here in 1976. A default by the person debtor would give the creditor the right to take the body of a slave freedman security into custody. The body of a slave freedman or person has value, while the body of One of the people, or a free man, does not, since he is not property nor person, not a creation of man, and, most of all, did not receive his liberty from Congress, for which he owes a return, and therefore his body is not a security and has no commercial value to anyone but him. So that takes us to that verse we read from Isaiah. So there is no value to the body of a free man, right? One of the people. But a slave freed man has value, commercial value. So we have here the body of a freeman does not admit of valuation. The court indicates that a liberty interest may have either of two sources. Liberty interest. So liberty. According to the court, a liberty interest may originate in the Constitution, ante at 226, or it may have its roots in state law. Apart from those two possible origins, the court is unable to find that a person has a constitutionally protected interest in liberty. If man were a creature of the state, the analysis would be correct. But neither the Bill of Rights nor the laws of sovereign states create the liberty which the Due Process Clause protects. I had thought it self-evident that all men were endowed by their Creator with liberty as one of the cardinal, unalienable rights. And that was from Justice Stevens in that 1976 case. This is a good one to read again. If man were a creature of the state, the analysis would be correct, right? That a person has a constitutionally, that court is unable to find a person has a constitutionally protected interest in liberty. If man were a creature of the state, the analysis would be correct, but neither the Bill of Rights nor the laws of sovereign states create the liberty which the Due Process Clause protects. I had thought it self-evident that all men were endowed by their Creator with liberty as one of the cardinal, unalienable rights. I believe the previous quote explains the situation quite well, comparing liberty of a person to liberty of a man. It is good if you can see the difference regardless of what words and phrases are used. Does the context of the writing refer to the character of a slave freedman, or does it refer to the people as creations of God? The authors and creators of states, constitutions, and indirectly the governments based upon republican principles as opposed to democracies? People, as creations of God, have rights antecedent to the creation of states and constitutions. Before ending this section, the word individual should be addressed, since this section began with Title 26, concerning an income tax on individuals. So now we get on to the main topic of today's broadcast, which is the individual. And with that said, let's jump over here to the chat and make sure we're up to date. And it seems as we are. And if you just arrived, please make sure you hit the like to make sure that notifications get out there. All right, let's proceed. First, we should know that the word individual is an adjective, not a noun. The obvious question is, an individual what? You probably would not think the word individual could be used to describe a corporation, an artificial entity, also known as a legal person. So person, an individual, or an organization. And that's from Ballantyne's Law Dictionary, 1969. Interesting, individual as an adjective. Let's continue. Individual, adjective, existing as an indivisible entity. 2. Of or pertaining to a single person or thing, as opposed to a group. And that's from Black's Law 7th edition. Entity, an organization such as a business or a governmental unit that has a legal identity apart from its members. So it's a legal identity that's apart from its members, which, well, they would be indivisible entities. Governmental unit, a subdivision, agency, department, country, parish, municipality, or other unit of government of a country or a state. The term includes an organization, an entity with a separate corporate existence only if the organization can legally issue debt obligations on which interest is exempt from income taxation under national law. Governmental unit. Separate corporate existence only if the organization can legally issue debt obligations on which interest is exempt from income taxation under national law. Wow. And that's from Black's Law 7th edition, too? I do not see any references to men or people in those definitions, but you can always volunteer. Interesting there. And governmental unit, I wonder if this still holds true with what we have here, the 9th edition. Let's check out through here the 9th edition and see what we have here for governmental unit. Bear with it as we go through this scanned copy here. It takes a while to catch up. In the meantime, we can always find some serendipitous definitions along the way. So we have here deceasus, to depart. Roman law, a death, a departure. Okay, here we go. It's moving again. All right, come on. It just stalled a little bit here. Bear with me. We're getting there to the G's. All right, it's going to really take a while here for a second, but it'll catch up with us. In the meantime, let's check over here to the chat. Now I went too far. Governmental unit. Should be getting close. All right. Golden rule. Good moral character, good Samaritan, goodwill, and govern. Government. Government. These are all government. Agency. We want governmental unit, right? The little trust unit, here it is, a subdivision, agency, department, county, parish, right? Term includes an organization with separate quarters only if the organization can legally issue debt obligations on which interest is exempt from income taxation under national law. Interesting there. So this still holds true to the 9th edition, which is a lot more current. All right. So back to where we were. There it is. Individual as a noun. This term denotes a single person as distinguished from a group or class, and also very commonly private or natural person as distinguished from a partnership, corporation, or association. But it may, in proper cases, include artificial persons. That's State versus Bell Telephone, Ohio. And that's from 4th edition. Black's Law, the individual as a noun, single person. So far I see here person, natural person, artificial persons. Did you notice many references to persons in that quote? According to the Uniform Commercial Code by Anderson and according to other authors on the UCC, one finds that an individual is considered as an organization, but individual may be used more specifically to mean the one man or one employee corporation. The term organization is generally used to mean a legal or commercial entity with 2 or more persons. It is also said that the UCC is written from a civil law view rather than common law, or we could say law merchant. Corporations are persons, as that word is used in the first clause of the 14th Amendment. That's Covington and L. Term something. Okay. Black's Law, that's 4th edition, person. Corporations are persons, as that word is used in the first clause of the 14th Amendment. Corporations in the civil law are legal persons and are subjected to the will of their creator, corporations, and fit within the intent of the 14th Amendment. The list of entities shown in 1 U.S.C. 1 shown earlier would also be creatures of the government of the United States. The creator controls its creation. This corporation is a creature of the United States. It is a private corporation created for public purposes, and its property is to a large extent devoted to public uses. It is therefore subject to legislative control so far as its business affects the public interests. That's Chicago, Burlington, Quincy Railroad in 1878. Sinking fund cases. If the state created the company and its franchises, it surely may make regulations as to the manner of using them. All this really comes down to who is creating what. The creator controls its creations. This is why it is important to know who you are and who your creator is. And be careful when you volunteer to be something you are not. Important words there. This brief review shows how people who hold freedom and liberty in their hearts can be confused and bewildered when someone changes their country into a society of slaves and freedmen, complete with new and special courts, administering positive law and equity, different types of law, civil law and positive law, a different form of government, democracy, and a different form of money or account with an accounting system and paper currency instead of money of exchange. Having said all this, you should know there is remedy and recourse. As much as someone may try to alter your thinking, you are a man of God, a creature of your Creator, who is of a higher authority over men. It is obligations that can tie one to earthly powers. So you might consider extinguishing all such duties and obligations. Remember that slavery and involuntary servitude are said to be contrary to law, but not when they must be a typo here, not when they only address persons. Do not forget you have a higher role or character as a divine man or woman of God and as a creator of the American institutions. Interesting there. Now we're on to section 3. Let's jump over to the chat and see where we're at. Looks like we're still caught up there. Let's get on to fictions here. In case it is not obvious, there are many fictions incorporated into the type of law being used today, as we have all probably witnessed. There's always a situation when speaking of a state of society, which is based upon fictitious fictions in an unnatural order of things in contrast to a state of nature. A closer study of history shows that there are a few persistent associations that want nothing more than to enslave or control a large number of people. This occurred in the Roman Empire, the British Empire, and now the United States Empire. To accomplish this feat, legal writers had to develop a legal system based upon fictions. While God created man and gave the people responsibility as trustees to oversee or care for his creations, others have created other concepts or relationships involving entities to which they give the designation of person. If we do not understand the work of fictions, we will not understand how it is possible that legal writers can create a slave-like personification and then get men and women to accept or acquiesce to such titles or offices, thereby giving a fictional, slave-like status to people who ought to be free with liberty. There's bound to be chaos and friction when people who believe in freedom and liberty are treated as slaves in order to follow commands of a supposed superior authority of unknown or foreign origin. Fiction of law. The assumption that a certain thing is true, and which gives to a person or a thing a quality which is not natural to it, and establishes, consequently, a certain disposition which, without the fiction, would be repugnant to reason and to truth. Interesting there. It is an order of things which does not exist, but which the law prescribes or authorizes. It differs from presumption because it establishes as true something which is false, whereas presumption supplies the proof of something true. For it is said that every fiction must be framed according to the rules of law, and that every legal fiction must have equity for its object. To prevent their evil effects, they are not allowed to be carried further than the reasons which introduce them necessarily require. 5. Wow, this is intense here. The law abounds in fictions, where he severely censures these fictions as absurd and useless. I'm not going to read all that. Legal fictions perform their twofold office, transforming a system of laws and of concealing the transformation. Legal fictions' twofold office of transforming a system of laws and of concealing the transformation. Wow. It is clear that the corporations taken as a unit must be treated by the courts and legislatures in that somewhat complex fashion which we epitomize by saying that legal rights and duties are attributed to the corporation. It is further clear that this treatment of the corporation bears a striking resemblance to that accorded natural persons. It then follows that natural persons and corporations are to some extent treated in the same way in the law. They form a class. Natural persons and corporations are a class, assuming, however, that it is worthwhile having a name for this common class formed by natural persons and corporations, is the word person. The most desirable name? Would legal subject be better? Or right and duty bearing unit? Wow. Yeah, is person the most desirable name for this class? Laymen frequently complain of the law. They are very seldom complain that it is founded upon fictions. You might erect a legal world in which silence is consent, taking is finding, attracting is inviting. To bring a suit is to achieve Roman citizenship. A world in which even the commonest expressions were to be understood in Pickwickian sense. This attitude has indeed been dignified by the name, the theory of the juristic truth of fictions. The theory of the juristic truth of fictions. So again, the fictions make what's false true. And that was from I guess that was from over here, right? Yeah, indeed. It establishes as true something which is false. This comes from Bovier's. Legal fiction, an assumption that something is true even though it may be untrue, made especially in judicial reasoning to alter how a legal rule operates. That's your transformation. The constructive trust is an example of a legal fiction. So a constructive trust that's created by the court. Legal fiction is the mask that progress must wear to pass the faithful but blear-eyed watchers of our ancient legal treasures. Wow. But though legal fictions are useful in thus mitigating or absorbing the shock of innovation, they work havoc in the form of intellectual confusion. I do not think there are any limits to the use of legal fictions in a state of society, and it is not easy to observe all the fictions in court cases, law dictionaries, bank loan agreements, and income tax returns. All right, let's jump over here to the chat and see where we are here. Oh, it's Verily. Welcome. I know you're not giving a lecture. Wish you could pause and give a quick breakdown of certain parts of this. Indeed, we'll do that for you. So let's see here. Get that off the screen. And let's get back to where we were. All right, so let's get back here. So the parts we're going over in this book here, we'll get to the table of contents here. This will give us a better outlook here. So right now we've already been through the introduction of this, the Society of Slaves and Freedmen, where we made the differentiation between free men, or people that were slaves and then freed, which still owed an allegiance to their masters as a gratitude for being left free, which the 14th Amendment has now taken that role as that entity of granting freedom to the slave. And the amount of servitude is owed, but you still have freedom of travel outside when you're away from the master. But when you're in the presence of the master, then you're the villain. We went over fictions, what we're going over right now. And then we're going to go over statutory construction, the creation of a person, human being, a natural person, and then the summary. So we're about a little over halfway through the book, and I hope that gets you up to date. And let's get back to where we were here, which I believe was on fictions. But actually, now we made it to statutory construction. One step ahead. We have James Allen Cooper. Greetings. Justinian uncle Justin Roman Emperor perfected the corpus juris secundum, a demon Roman system that Baal controls from the underworld. Indeed. All right, so now we're going to get over statutory construction. So these are statutes, statutory construction. A short discussion of statutory construction is provided because in defining the legal words used in a state of society, there are usually lists of things associated with a given term. All the entries in a list of items included under a particular term are to be viewed as having the same character. That is, you would not find a man created by God in the same definition of a word addressing a corporation created by the state. Okay. So let's get these classifications right. Applying the maxim of statutory construction, I'm not going to read the Latin, that a word is known by the company it keeps. A word is known by the company it keeps. That's from Ashcroft, 1991. Nos nascaturas. Okay, is a rule of construction applicable to all written instruments. We could take a quick break and get that one. Okay. My Latin's awful, but that's why we have, hey, metal, greetings. And we have the audit them. Salute to you. All right, we have to get to nascatur. Let's get to blacks, and let's find nascatur. Bear with it here as it goes very slowly. L. Larger parcel. Involuntary. Yikes. All right. Mortgage transaction. All right. So we are on, we must be on M. Yep. All right, see if we can get to the ends a little bit quicker here. Bear with me. There we go. And E. Okay, whoa. This doesn't even have the little things on every top of the page. Makes it a terrible scan document, but this is what we got to deal with, so it's all here. This is the 9th edition, so it's rather current, as most of the texts we have refer to the older editions, and I'd like to see if there's been any changes over the years. Good way to get a feel for the pulse. Okay, we passed it here. Note. Nos. There we go. Noscatura. Here it is. Nositore. Wow. Nositore. Ora. Nositara. Or Nositore. Socius. Nositore Socius. Ooh. Latin. It is known by its associates. 18th century, a canon of construction holding that the meaning of an unclear word or phrase should be determined by the words immediately surrounding it. Oh, here's another great word. The generous rule is an example of a broader linguistic rule or practice to which reference is made by the Latin tag nositare socius. Nositare socius. Which is made by the references made by the Latin tag nositare socius. Words, even if they are not general words like whatsoever or otherwise, preceded by specific words, are liable to be affected by other words with which they are associated. Great. So that's nositare socius. All right. Well, I'm glad we got the pronunciation of this down. That's a hard one. I got to say it a few times to really get it down well. Nositare socius. All right. Let's continue. And let's see what we got here. Especially interested how a difference between civil and common law. I know that was a while back. Okay, so civil and common law, what they're getting at here is that none of this applies to common law anymore. It's all been supplanted by the civil or the law merchant, UCC, as we see all the references to here, commercial code. And that's because they've done this transformation of creating this artificial entity of a person and using it in a commercial construct. And using this transformation and concealing it is a way that free men and women are getting fooled into thinking they are freedmen or freed women. Insanely quasi word. I only know pig Latin. Yeah. Well, now I'll be able to say it correctly for the remainder of this broadcast. So thank you all for bearing with me. Nositare socius is a rule of construction applicable to all written instruments, whether any particular word is obscure or of doubtful meaning taken by itself. Its obscurity or doubt may be removed by a reference to associated words. And the meaning of a term may be enlarged or restrained by reference to the object of the whole clause in which it is used. The object of the whole clause. So this looks like a pretty powerful concept here. Difficult to say, but powerful in use as a rule of construction. Nositare socius. Of the same kind, class, or nature. In the construction of laws, wills, and other instruments, another great word here, rule is that where general words follow an enumeration of persons or things by words of a particular and specific meaning, such general words are not to be construed in their wildest extent, but are to be held as applying only to persons or things of the same general kind or class as those specifically mentioned. Okay. How would you read the following statute? All right, here's our little test. Person includes a corporation, company, partnership, firm, association, or society, as well as a natural person. And that's from Arizona Revised Statutes, General Provisions, Statutory Construction. Could the phrase natural person refer to a man when the list it is associated with has only fictional entities or organizations? No. Where in a statute is there an enumeration of a special class of subjects followed by a general clause intended to embrace subjects not enumerated? The general clause will be construed to include only subjects which partake of the same nature as those already mentioned. There we're getting to Statutory socius. Penal statutes must be construed to reach no further than their words, and a person is not to be made subject to them by implication. Wow, that's from 1919. Same case, State versus Eberhardt. Now we're on to Section 5, the creation of a person. Indeed, all written instruments. So the word surrounding an uncertain term, we're going to define it. All right, based upon my study, the word person is used in reference to civil law, and a state of society is based upon the concept of slavery. More succinctly, the giving of a slave to the more prestigious status of a person in law. Also, we have seen the emancipation of a slave may be said to free the slave so he can be called a freedman. However, there remains a slavish or servile relationship to a master. The slave person has granted rights generally defined as the right of owning property, contracting, suing, and being sued, taxed and regulated, with rights and duties often spelled out in statutes and court decisions, along with a list of itemized constitutional rights. In the Roman era, when a slave was released from his prior bondage or slavery and given better conditions under civil law, the slave was given the title of person without any recognition of having a divine connection to God or Creator. The transformation of a slave into a person by operation of the civil law creates a new inferior citizen and provides the foundation for a moral duty annexed to the person to benefit the emancipator. The emancipator holds a moral right derived from the conditional or personal liberty he has given the slave person. One cannot be said to have an obligation unless he has received something first. Wow, so they get the moral right derived from the conditional or personal liberty. Conditional or personal liberty he has given the slave person. In the same context, foreigners who accepted the protection of the Roman Empire without discussing the use of threat, duress, or coercion were instrumental in establishing the law of persons under civil law. In either situation, slave or foreigner, the institution of the law of persons was based upon voluntary submission to the will of another. Foreigners who accepted protection is voluntary submission. Wow. Sir Henry Sumner Maine, in his book Ancient Law, speaking of international law for certain nations, says, the very conception of a common superior introduces the notion of positive law and excludes the idea of a natural law. Remember, positive law is not necessarily a good thing. It never is. This is administrative law. This is the law for slaves and subjects. The law of nature does not uphold the concept of slavery or man being subject to the will of another. That every human being has a right to liberty as well as to life and property, and to enjoy the fruits of his own labor. That slavery is contrary to the principles of natural right and to the great law of love. That is, slavery is founded on injustice and fraud and can be supported only by the provisions of positive law, are positions which it is not necessary to prove. The very idea of slavery implies that the slave is one who is in subjection to the will of another. Wow, that was from 1857. The following quote provides a more basic understanding of the use of the word person. Person, a Latin word signifying primarily a mask used by actors on a stage. 6. Character of office. How different is the same man from himself as he sustains the person of a magistrate and that of a friend. Wow. Here we have 8. In law, an artificial person is a corporation or body politic. That's from 1828. Notice the reference to the person of the magistrate. A magistrate holds a public office and has a public function. Also, corporation is said to be created for public purposes. The civil law deals with public offices and persons serving a public purpose. Tollier has given us the derivation of the word person, which will render sufficiently clear its true meaning. He says, the word person, in its primitive and natural sense, signifies the mask with which actors who played dramatic pieces in Rome and Greece covered their heads. These pieces were played in public places, and afterward in such vast amphitheaters that it was impossible for a man to make himself heard by all the spectators. Recourse was had to art. The head of each actor was enveloped with a mask, the figure of which represented the part he was to play, and it was so contrived that the opening for the emission of his voice made the sounds clearer and more resounding. Vox personabat, whence the name persona was given to the instrument or mask which facilitated the resounding of his voice. The name persona was afterwards applied to the part itself, which the actor had adapted to the age. Part itself, which the actor had undertaken to play because the face of the mask was adapted to the age, and a character of him who was considered as speaking, and sometimes it was his own portrait. It is in this last sense of personage, his own portrait, or the part with which an individual plays, that the word persona is employed in jurisprudence in opposition to the word man, homo. When we speak of a person, we only consider the state of the man, the part he plays in society, abstractly, without considering the individual. Again, we see reference to the word public and to the part one plays in society or a state of society as opposed to a state of nature. In my prior writing called Resident Minister, it was reported that a resident is a public office serving a sovereign authority. To give jurisdiction to statutes and courts of positive law and equity, there need to be public persons or public offices as parties to the action or suit. To give jurisdiction to statutes and courts of positive law and equity, there need to be public persons or public offices as parties to the action or suit. Interesting here. I like to see the references to this one here. I guess we could look into this one here from Of Persons from Bouvier. But that's not what I'm looking for. Let's continue. Minister, international law. This is the general name given to public functionaries who represent their country abroad, such as ambassadors, envoys, and residents. A custom of recent origin has introduced a new kind of ministers without any particular determination of character. These are simply called ministers, to indicate they are invested with the general character of a sovereign's mandatories without any particular assignment of rank or character. Ooh. And that's just ministers. This seems like an appropriate place to insert the following regarding Title 26, Income Tax and Public Office. 26 U.S. Code 1402A, the term net earnings from trade or business means the gross income derived by an individual from any trade of business. Let's break this down. Net earnings from trade or business means the gross income derived by an individual. Wow. Okay, we could go all day with these words here. Income. All right. 26 Code of Federal Regulations 1.1402C. In order for an individual to have net earning from self-employment, he must carry on a trade or business. Trade or business shall have the same meaning as when used in Section 162. And here's Section 162. This section describes persons in public office, which corresponds with that one finds in 7701. Here's 7701. The term trade or business includes performance of the functions of a public office. Again, we see reference to a public office. A corporation, even though private, may have a public purpose. The word private is relative, so it is not good to just assume the word private is referring to men or to the people. This corporation is a creature of the United States. It is a private corporation created for public purposes, and its property is to a large extent devoted to public uses. It is therefore subject to legislative control so far as its business affects the public interest. And that's from our Quincy Railroad Company. In the state of society with its civil law system, the focus on the fictional cloak or mask. This is intended, so only the fictional character can be seen, and not the real man or woman as a divine creation under the cloak or behind the mask. It is as though all the world is a stage. We are but actors assigned to play a particular role in the drama. Or is it a comedy? Yeah. Person, a human being, an entity such as a corporation as recognized by law as having the rights and duties of a human being. 3. The living body of a human being, contraband found on the smuggler's person. Artificial person, an entity such as a corporation created by law and given certain legal rights and duties of a human being. A being, real or imaginary, who for the purposes of legal reasoning is treated more or less as a human being. Also termed fictitious person, juristic person, legal person, moral person. Natural person. A human being is distinguished from an artificial person created by law. So we get this person having human being, and we have artificial person, natural person. All right. Use your imagination for a moment. A whole person consists of a natural person and an artificial person. An artificial person is composed of natural persons. An artificial or legal person cannot think, speak, or act, so it needs something called a human being to think, act, and speak for it. Communications to the legal or artificial person go to a natural person as one who can read, write, and speak. The artificial person cannot go to jail. It is a piece of paper. A natural person must step forward for the punishment that is rendered against the artificial person. This is a little deep and beyond the scope of this writing, but that is pretty, has some pretty strong implications here. Let's get back to the chat. Whoa, boy. What document is this being read from? This is from the Treatise of Slaves and Society of Slaves and Freedmen. As we're getting into here, indeed. Bill Thomas says a farmer feeding his own grain to his own animals was considered commerce under the law. Interesting. 7th edition Black's Law Dictionary is what this has been mostly referring to. There's some in 4th edition here, and I have 9th edition at the ready just to verify anything has changed over time. All right, let's get back to definitely a comedy. Yeah, it's not a drama. The joke's on us. Indeed. Indeed. I think we're just getting trolled. The people are being trolled. All right. Oops. Okay, there we go. All right, the artificial person cannot go to jail. It's a piece of paper. A natural person must step forward for the punishment that is rendered against the artificial person. It's a little deep and beyond the scope of the writing, but we get it. Many people have been confronted with this question. You are a natural person, aren't you? To answer that question, one would need to investigate the term human being. Which brings us to section 6. And we're getting pretty close to the end of the reading here. We might be able to make it through. To understand what is meant by a natural person, we need to know the definition of a human being. Most people would accept the statement that they are human beings. However, it might be wise to research this label. The following is my best effort to uncover the meaning. You might want to consider these definitions are describing a slave and man-like creature, or defining man as a divine creation of God. Separating hue from man, hue or hue can refer to the color, form, or appearance. Therefore, the word human would describe a thing that has the form or appearance of a man, or resembles a man. Human, belonging to man or mankind, pertaining to or relating to the race of man. 2, having the qualities of a man. Human, or the form or characteristics of a man, from Valentin's Law Dictionary. Human being, a person, male or female. Interesting. You notice the references to having the form or characteristics of a man, but they generally will not say human is a man. The following definitions get more to the point. This is funny here saying a person, male or female, but still a person. Human being, still a person, not a man. The forms or characteristics, indeed, having qualities, belonging to, pertaining, or relating. Human, 3, profane, not sacred or divine. Jeez. Being, 3, a person existing, applied to the human race. An animal, any living creature. Again, 1828 Webster's Dictionary. Mr. Webster had a more flattering definitions of the words human and being, but if a scheme could be designed to corrupt the law and keep us from expressing our true self, we must look for the possibilities and the facts. We have not seen it stated that sovereignty, common law rights, or the law of nature pertain to human beings, have we? Human being, see monster. Monster, a human being by birth, but in some part resembling a lower animal. Jeez. A monster hath no inheritable blood, and cannot be heir to any land, albeit brought forth in marriage, but although it hath deformity in any part of his body, yikes, yet it hath human shape, it may be heir. Jeez. 1948 edition. Sounds like genetic experimentation, although they are speaking of a Frankenstein creature having the form of man. Human, 1, of, belonging to, or characteristic of man, of the nature of man, that is a man, consisting of men, belonging to or relative to man, as distinguished from God or superhuman beings, pertaining to the sphere or faculties of man, the implication of limitation or inferiority, mundane, secular, often opposed to divine. Notice the words often opposed to divine. Modern writers on ancient history have studied ancient manuscripts, writings on stones, tablets, scrolls, and ancient history passed down from generation to generation. They have found there were attempts to reduce man to a condition of slavery, to serve a race that wished to be masters or controllers over the planet. There are also indications of genetic manipulation in ancient history. If we knew more of our history, we would not be so surprised at the information contained in this writing. Also, if we knew this history, we would not be so easily misled. Human, adjective, 1, of, pertaining to, characteristic, or having nature of mankind. 2, consisting of people or men, the human race. 3, of or pertaining to the social aspect or character of a man. 5, a human being equivalent to Hume, see homo plus anus and homo, noun, the primate genus that includes a modern man, Homo sapiens, and a number of closely related extinct species such as Neanderthal man. And a suffix. Anus, a suffix occurring in scientific words of Latin origin, the opening at lower end of alimentary canal. Okay, we get that. In the third definition from Random House above concerning the social aspect or character of man, I naturally think of the characters one plays in a state of society where persons are subjected to the will of another. I believe the following quote is appropriate at this time. where the use of the word slave is further referenced by adding homo, a word associated with human. Mancipatio, civil law, the act of transferring things called res mancipi. This is effected in the presence of not less than 5 witnesses who must be Roman citizens and of age of puberty, and also in the presence of another person of the same condition who holds a pair of brazen scales and is hence called libripens. The purchaser, quae manicipio accipit, taking hold of the thing, says, I affirm that this slave, homo, is mine, ex jure quiritium, and he is purchased by me with this piece of money and brazen scales. All right. We're on to 7, the natural person. Let's get back with the chat here. Now you can make your own persona, also known as an irrevocable trust. Put all your assets into it and be the trustee. You will no longer have the issues in the public in general. Verily says, creepy indeed. Craig Harry says, kind of see someone may want to go by they, them now. Indeed. Trusts are rather complicated, and I do have a whole playlist on trust, express trust, pure trust. In general, there's quite a variety, and knowing how to have them constructed and usually making sure that there's no crossovers for the roles. But that's another subject. And again, there's a lot of have a lot of videos regarding trust, and probably will be releasing more in the future. So we're on to 7, natural person. We should be getting wiser to the methods at work that can adversely affect one's life, liberty, and pursuit of happiness. The following are more references to the concept called natural person. A slave is, and must, of necessity, continue to be a natural person, although he may be a legal chattel, or whatever may be his relations to the law. Wow. So a slave is and must of necessity continue to be a natural person, although he may be legal chattel, so property, movable property. A person is such not because he is human, but because rights and duties are ascribed to him. A person. The person is the legal subject or substance of which the rights and duties are attributes. An individual human being considered as having such attributes is what lawyers call a natural person. Natural. Of course, when you say natural person, it's still a person, so the modifier is not going to change the principle here. Related only by birth of no legal relationship, illegitimate. A natural son, wow. 20, unenlightened or unregenerate, the natural man. Unregenerate. 1, not regenerate, not renewed in heart and mind or reborn in spirit. Unrepentant, an unregenerate sinner. So like degenerate. Unregenerate is another one. Not renewed or reborn is unrepentant. Refusing to believe in the existence of God, an unregenerate atheist, an unregenerate skeptic. But the natural man receiveth not the things of the Spirit of God, for they are foolish unto him. Neither can he know them, because they are spiritually discerned. Do you want to call yourself a natural man? Do you want to call yourself a natural person? Be careful of the label you accept. The following quote is saying a corporation can be considered a natural person for certain purposes. A corporation is an intellectual body created by law, composed of individuals united under a common name, the members of which succeed each other so that the body continues the same. Wow. Notwithstanding change of individuals composing it, and which for certain purposes is considered as a natural person. So a corporation, intellectual body created by law, the members which succeed each other so the body continues the same, notwithstanding change of individuals composing it, and which for certain purposes is considered a natural person. Jeez. Maybe we should be more careful about the descriptive words we accept to identify who we are. The following quote was found in Melanoff's Dictionary of American Legal Usage by David Melankoff, professor of law emeritus, University of California, Los Angeles, published by West Publishing. Okay. Person, an indispensable word with varied. Oh, you can see how confusing the fictional world can be. So, person, an indispensable word with varied overlapping meanings, often used without definition, as in U.S. Constitution, Articles 1, 2, 3, 4, Amendments 4, 5, 7, 9, and 12, defined and redefined in an endless succession of special purpose statutes with no assurance to the profession, that is, the person you thought you were talking about. 1. Human being, without regard to sex, legitimacy, or competence. This person is the central figure in law, as elsewhere characterized by personal attributes of mind, intention, feelings, weakness, morality, common to human beings, with rights and duties under law. This is the person, sometimes called an individual and often referred to in law as a natural person, as distinguished from an artificial person. 2. The physical, biological being. This is the person who is injured or killed, the person of injury to the person, and of firearms concealed upon the person. This sense overlaps the sense of the person with rights, sense 1. No person shall be excluded on the basis of sex. Overlaps again with the question of when one becomes a person. Existing person, a child unborn, and venturous, a person for purposes of inheritance, but not a person in the criminal law generally. As of this writing, the abortion controversy, a person as used in the 14th Amendment does not include the unborn. 3. An artificial person, an abstraction of convenience regarded by law as a distinct being, having the existence independent of those who create or own it. So an artificial person, independent existence, independent of those who create or own it. The classic example of this person is the corporation, a being distinct from its shareholders, in its own name owning property, contracting, suing, and being sued, taxed and regulated with rights and duties often spelled out in statutes and constitutional decision. A labor union and a business trust have also been described as artificial persons. The expressions juristic person and legal entity are frequently used as synonyms of artificial person. Yes, the legal construct of the juristic person. 4. Legal entity, often described as a person, is itself an expression without uniform meaning. So this is all from Melanoff's Dictionary of American Legal Usage, page 479. So as we saw from the author here, he clearly warned us, you can see how confusing the fictional world can be. Quite confusing. All right, hopefully this will make sense now that we've made it to the summary. And just to check in with chat, it looks like we're all caught up. There's much more that could be written on this subject, but I believe there is enough information provided here to see how easy it can be for someone to be viewed in unflattering descriptions by using words generally not fully understood by people. It must have required a huge effort to create a system for slaves and freedmen without making it obvious to the people. Remember, where ultimate authority lies, you are still a creature of God, the Creator, and have that character which is of higher authority than those characters designed by men. You have a higher law to bring to the table. You do have a higher source of authority than those who concocted the feudal or civil law system, and including the law merchant. However, if you do not understand how you or the legal entity over which you may be considered a trustee are being perceived in the statutes and courts, that you may neglect to act in a manner best suited to your freedom and liberty. Even with all the smoke and mirrors, the state government are functioning as a trustee for the people. Future writings will more fully explore the notion of bringing your law to the front if you deem it necessary. And we have an appendix to the opinion of Douglas J. Dissenting. Because we hold it for a fundamental and undeniable truth that religion, or the duty which we owe our Creator and the manner of discharging it, can be directed only by reason and conviction, not by force or violence. The religion, then, of every man must be left to the conviction and conscience of every man, and it is the right of every man to exercise it as these may dictate. It is the right in its nature, an unalienable right. It is unalienable because the opinions of men, depending only on the evidence contemplated by their own minds, cannot follow the dictates of other men. It is unalienable also because what is here a right towards men is a duty towards the Creator. It is the duty of every man to render to the Creator such homage, and such only as he believes to be acceptable to him. This duty is precedent, both in order of time and degree of obligation, to the claims of civil society. Before any man can be considered as a member of civil society, he must be considered as a subject of the governor of the universe. And if a member of civil society who enters into any subordinate association must always do it with a reservation of his duty to the general authority, much more must every man who becomes a member of any particular civil society do it with a savings of his allegiance to the universal sovereign. We maintain, therefore, that in matters of religion, no man's right is abridged by the institution of civil society, and that religion is wholly exempt from its cognizance. True it is that no other rule exists by which any question may divide a society can be ultimately determined but the will of the majority. But it is also true that the majority may trespass on the rights of the minority, because if religion be exempt from the authority of society at large, still less can it be subject to that of the legislative body. The latter are but the creatures of the vicegerents of the former. Their jurisdiction is both derivative and limited. It is limited with regard to the coordinate departments. More necessarily, it is limited with regard to the constituents. The preservation of a free government requires not merely that the metes and bounds which separate each department of power may be invariably maintained, but more especially that neither of them be suffered to overlap the great barrier which defends the rights of the people. The rulers who are guilty of such an encroachment exceed the commission from which they derive their authority, and are tyrants. The people who submit to it are governed by laws made neither by themselves nor by an authority derived from them, and are slaves. Because it is proper to take alarm at the first experiment on our liberties, we hold this prudent jealousy to be the first duty of citizens, and one of the noblest characteristics of the late Revolution. The freemen of America did not wait till usurped power had strengthened itself by exercise and entangled the question in precedence. They saw the consequences in principle, and they avoided the consequences by denying the principle. Excellent. That was from Byron Beers. Of course, he's quoting the Waltz versus Tax Commission of New York in 1970. Excellent. So Going to Pieces' his website, and that's where you can find this text and others. And let's jump over here and see what we got here on the chat. Yeah, that's a good one there, huh? Vicegerents. You can look that one up here, but I'll just give you a general definition of it because I don't think that's yeah, it is. The vicegerent, let's see, vicegerent, a person exercising delegated power on behalf of a sovereign or ruler, a person regarded as an earthly representative of God or a god, especially the Pope. Oh, okay. So it's a vicegerent, and that's your Pope. Okay. And Soul Free says real and righteous, physics, logic, and honor. All right, and I think that's it with the chat. Indeed, we're all caught up there. Yep, you got it there, Bill Thomas. We got to keep up with these justices here. They like to use big words just to, again, the concealment is part of the process of keeping people enslaved. So if they only knew how it was being done, they wouldn't put up with it. And that's how we ended up with, as the title is here, the Society of Slaves. So I hope this reading has helped empower everyone to see a little bit more of the nuances with all these different words that are used to control us in a society of slaves and freedmen. So please hit the like, and if we get good positive feedback on this one, I'll go on some more of the text we have here from Byron Beers that carry on the same topic as he alluded to in the text. So with that said, I salute you all for being here, and I hope to see you all on the next one. Peace out.